Hey, welcome live from America podcast. This is Hatem alongside me, the one and only Danny Cevallos, legal analyst, NBC, a friend, podcaster as well, right? You have a show happening right now.
I do. We have relaunched the Danny Savala show with my wife Sarah Ganem, and it's going great. But you know how it is. It's a lot of fun, and it's always a good conversation. But I'm glad to be back on Live from America with the great Hatem.
Oh,
Thrilled to
thank
be
you.
here.
Yeah, you are amazing. You really are like one of the my favorite guests because we go through stuff and you just the way you break it down is excellent. And I gotta say, I just gotta give you a compliment on your show because I've been watching it. And I swear it's not promotion, it's not anything like that, but it's one of those shows that you listen to. It's also the way you speak and Sarah as well. It's like you don't want to turn away. Like, when you listen to a show, you watch a movie on your phone or something, it's one of your shows that it's amazing. Well,
Wow.
I recommend everybody that go watch it if you
Well,
can.
thank you. Boy, that really means a lot coming from you. Thank you very much.
All right, let's start a crazy day, crazy week, crazy month. It's always when you're a legal analyst and a lawyer and attorney and one of the top in the city, you always have shit to do and stuff to do. So let's talk about it. The first thing is the landmark social media addiction trial.
Absolutely.
If anybody doesn't know what is it, why is it landmark, and why is it like what is the social media addiction trial?
It's landmark because of the theory of liability. And the theory of liability is this: you have a plaintiff who alleges that when she was young, 10 years old, she got hooked on Instagram, she got hooked on social media. And as a result, she suffered adverse health consequences, specifically mental illness. So the plaintiffs have to essentially prove that these social media companies, and they have brilliantly frame this as akin to tobacco litigation. I don't think it is like tobacco litigation, but it's smart. If I were the plaintiff's attorney, that's the way I would market this. I would say that their theory is that this is exactly like tobacco litigation. Or maybe you could say it's like opiate litigation, in that they allege that Facebook, Instagram, even YouTube is a defendant, which is interesting. We can talk about that because is YouTube really a social media company? Probably, but I don't think people consume it that way. Still, the theory is that these companies knew at some point that their product was harmful and could cause clinical addiction in young people, in children. And that's another strategic advantage for the plaintiffs, because when you use underage minors as your plaintiffs, then you really have less of a defense coming of, hey, they know what they're doing, they're making decisions. No, in our society, we say that minors don't have that capacity to make decisions for themselves. It's very interesting, by the way, that the law on something like that is essentially neurology, when is somebody responsible, not only has it changed so much over time, it varies from state to state dramatically. Look at all the differences in consent laws that we have. And they may vary by a few years here and there, but I think that's pretty significant. We have different rules for when you can go into the army. We have different rules for when you can consent to sexual relationships, to when you can drink. It's uniform in the United States, but only because the federal government essentially bribed with highway funds every state to make it 21 years old. So we have different ideas of what is the age of majority and when people are responsible. So smart for the plaintiffs to take an underage minor, someone who was an underage minor, and say that using these social media products caused adverse mental health consequences, whether that be suicidal ideation or other kinds of mental illness. So that's what the plaintiffs have going for them. Their theory of liability is that these companies knew during their research that these products were addictive. And the magic word for them is addictive. And it's interesting because we all think of addictive in different ways. There's clinical addiction, but you might socially say, "Oh my God, I'm addicted to chocolate," which means maybe you have trouble controlling yourself with M&Ms on Friday night, like I do. But would it rise to the level of clinical addiction? Probably not. Maybe it's a vice. So a lot of this case comes down to framing the defendants as knowing the product was addictive and therefore harmful, clinically addictive, and pushing it out anyway. Now, the defense, the social media companies, as I see it, have really three categories of defense. The first is this: look, no product is 100% safe. Motor vehicles are not 100% safe. Guns, obviously, but even water. Water, as I'm drinking now, if you don't have enough water, you get very, very sick and die. If you have too much water, you get very sick and die. And yet, water we think of as healthy. And I know it's kind of an absurd comparison, but the point is every product is potentially harmful, or as the defendants have seized on the magic word, problematic, not clinically addictive, problematic. So their argument is going to be not every product is 100% safe. We did everything we could. And as a corollary to that, part two would be that, look, we did everything we could. We did all the testing we could. We made it as safe as we possibly could. But number three is probably their biggest defense. And it's specific to this plaintiff, which is what we call causation. In other words, even if the defendants were negligent, causation is the idea that the plaintiff still has to prove that what they did caused her harm. And here's where it's very different and distinct from tobacco litigation. Because in the case of tobacco litigation or opiates, tobacco litigation is a good example. You can show that inhaling carcinogens causes adverse health consequences, namely lung cancer. Science can show that. I'm not so sure that science can show that doom scrolling on your phone at 11 o'clock at night, or maybe that filters making everybody look beautiful gives you bad self-esteem. I'm not so sure you can show that those things cause mental health problems, or that they aren't caused by other things, bad parental relationships, genetics, medication, environmental factors other than social media companies. But the magic words are substantial factor. If the plaintiffs can show that that these harmful social media properties were a substantial factor in causing the injury, namely mental illness, then they can win. But I think they have an uphill battle because causation, I'm not so sure they can show or prove to a jury, and they don't need to prove beyond a reasonable doubt, just preponderance of the evidence, which is 51%. They need to try and convince a jury that the product was harmful and it was addictive, and that they knew it was addictive, and that they let it get in the hands of kids. I think that's quite a bit to try and prove.
Um, I have so many questions, and so much to say. But if we take a step back, like just to the trial itself, who are accused? What are they, and who is accusing who, and what they want? What they asking for? And is it unique that it's a jury?
No, it's not unique. I mean, this is a case that was, it proceeded in the way almost all cases do, is a civil complaint filed in court, and that's going to get you a jury trial. The parties could have elected for a judge-only trial, which sometimes you might want to if you have complex issues like social media. But if you're the plaintiffs, you definitely want a jury trial because you might be able to play on the emotions. And I think that's kind of been some of the strategy of the plaintiffs' attorneys. You may be able to play on some of the emotions of the jurors if you can show that there were kids involved. And you have now these CEOs testifying who are making, millions of dollars. You have Mark Zuckerberg, one of the richest people in the world. That's a dream for plaintiffs' attorneys because they come into the courtroom with the jury already thinking, oh my gosh, here's a rich guy, he doesn't care about us. I mean, obviously they would have voir dired them and made sure the jury isn't inclined to not like Mark Zuckerberg. But it's very easy for Mark Zuckerberg testifying today as we speak to come off as a villain. And the plaintiffs' attorneys are trying to do that as we speak. I've been reading testimony as it's sent out by the NBC folks who are in there in the courtroom. And the plaintiff's attorney is going after him. But there are some things I think have been ineffective. For example, asking Mark Zuckerberg how rich he is, how much money he makes from Facebook, how Facebook uses engagement to drive their profits. Look, if you have even a rudimentary knowledge of business, that's how social media companies make their money. We don't pay for them. We pay for LinkedIn if people do that, but for the most part, they're free. And if the product is free, generally, you are the product. It's in a way, that's another way it's different from tobacco litigation in that you go to the store, you buy cigarettes, you've paid money, and the cigarette is the product you want. But that's not the way social media works. People by now, social media has been out for 20 years or more. People have to understand now that when they get this free product and companies are spending billions of dollars developing it and it's totally free, that they're the product. They're the
Mm.
kind of in the Matrix. They're those little red capsules, drawing the energy off the bodies of the people in the Matrix. I mean, that is, the people using it for free are the product. They're getting information about us. They're selling it. We're the product, and they're advertising to us.
So where is the location of and why was it chosen that location specifically?
It's in Los Angeles, in
Mhm.
the federal district called the Central District of California. Which, strangely, Los Angeles, being as south as it is in a district that's considered the Central District of California. I've always thought that was interesting. So, uh, this is going on in a federal courthouse. I believe that I don't know strategically why they would have filed in federal court, except that well, they certainly could. I mean, I think in all likelihood, LA is going to be a very good jurisdiction for them. I think they want generally people in city areas who are more who may know more about social media, maybe more aware of it than if you were in a deeply rural area. But I mean, the bottom line is that any jury you're going to get is going to have a hard time grasping the issues of algorithms. Even if you have an idea that your phone or your platform has an algorithm, we don't, not regular people don't really understand it. So the key for the plaintiffs is don't confuse the jury with algorithms and social media. Show that they tested these products, and they knew, if you can show it, that they knew that they were unsafe, and they pushed them out. Now the key is, what is the definition of unsafe? I think, do you think of unsafe as brakes that don't work on a car? Or do you think of unsafe so broadly that it's doom scrolling on a Friday night when you could be out going to the gym or going for a run or playing soccer? Certainly doom scrolling instead of playing soccer is not healthy, but is it harmful? Is it clinically addictive? Does it rise to the level that of the company putting out a product that is harmful? If so, that could be a floodgate when you think about it, because then Netflix, anything. I mean, anything that you enjoy doing that is a guilty pleasure is arguably something that is harmful. When in reality, I don't think we think of things that way. I don't think we think of drinking a soda. Well, let's not use a soda as an example, but sitting on the couch or reading a book when you should be outside in the sun. I don't know how each individual juror is going to define what harm is, but I think that is something the plaintiff needs to think about as they're presenting their case.
I think it's historic that it's moving from something that we consume to something that we choose.
Mm.
So if that's, like the example that you give, cigarettes or something like that, something you buy, something but now it's moving to choice, which is, you know, I think they want to say that it's influenced by other things that's around you, which is bring you to commercials. Is if you see a commercial for a certain car and you buy it and then you make an accident, something happens. Are they reliable for the commercial? I don't know. Who are the companies that involved in this, and why you think strategically they were chosen?
So some of the companies, the major companies, settled before trial. I was actually surprised this case went to trial. Remaining are, I believe, you have Facebook, Instagram, and YouTube. And that's very interesting because is
Who settled?
YouTube? No, YouTube did not. Those are the
No,
ones
no.
that
Who
are in
settled?
the
Who
trial.
settled before? Is
I
this?
believe it was Snapchat, and I can't remember the other one. I can't recall.
Okay.
I can't remember who settled. I'm pretty sure Snap was one of them.
Yeah.
So, but YouTube's an interesting character in this because are they social media? Well, you have a profile, people can interact with you, and you can post things. So I guess yeah, it is social media. But isn't it interesting? I don't think of YouTube as social media. And by
Yeah.
the way, of those, Facebook, Instagram, I mean, far and away, I use YouTube more than anything. I use YouTube hours a day. I listen to things. I have court tomorrow. I'm brushing up on field sobriety testing, and I'm using YouTube for that because it's an infinite resource of educational material. It's also an infinite resource of goofing off and ridiculousness that I engage in as well. And isn't it interesting? I never would have dreamed of thinking of social media as a defendant creating an addictive product, including YouTube. But maybe YouTube does count. I never thought of it. And isn't that funny? Because I use it far more
Yeah.
than Facebook, which I check, a couple times a day. YouTube, I'm on all the time. As soon as I get off here on the ride home, I'll have YouTube on. I'll be listening to some lecture.
Yeah. So, do you think it's a good strategy that, combine like it's bad enough that you fighting a big corporate in social media, the biggest? Is it a good strategy to have all, if I, like sue all of them? I know Facebook and Instagram is pretty much one, so they have to kind of go with one. But why include YouTube? Why include Snapchat, even if they settle? But why include all those?
Well, there's an old adage that in plaintiff's work, you sue everybody and let God sort them out. And there is rationale there because, anyone you don't sue, if the statute of limitations expires, then you've got problems. But that is a double-edged sword because the more people you sue, the more align in their defense against you. And the more people ultimately, assuming you go to trial, you have to prove your case against. And so it's not uncommon to name everybody and then drop people as the case moves on. But this ended up being a smart strategy because we know that some of the social media companies settled before trial, which is the goal. I mean, the unspoken goal of most lawsuits is settlement on the eve of trial, maximizing your dollar, taking it right to the eve of trial, and settling. And in a way, plaintiffs' attorneys, and I do plaintiffs' work, we all live in a delusional world where all day we're preparing for trials that statistically never happen. I mean, a tiny fraction of the cases I'm handling actually go to trial. But in order to do our jobs, we plan on all of them going to trial. And maybe the plaintiffs thought that all defendants would settle. Maybe that would have been optimal, maybe not. I don't know what their strategy was. But whatever the case may be, Facebook decided we want to go to trial on this. And I would have thought they would have settled. I mean, if I were the plaintiff's attorney in this case, I don't think I would have brought this case. But if I did, I think I would have anticipated they might have settled, but you got to be ready to go to trial. And I think the plaintiff now has a real battle on their hands. I've been listening to some or reading some of the testimony so far, and I don't know that they're scoring a lot of points. I mean, for example, they put Zuckerberg on the stand and they start asking him, how much money did you make from Facebook? Isn't the goal to make as much money as you can? Yeah, I mean, I think jurors get that. I think jurors understand that companies are in business to make money, and how much money? As much as they can. And it
Mm.
just happens that Facebook makes a ton of money and Zuckerberg makes a ton of money. So I don't think that's a surprise to anyone. And if that's all they have, and I know it's not, I know they have more. But if that's what they're opening with, I don't know. I don't know. I'm not so sure. But at the end of the day, the plaintiff has a very low burden to meet. Just preponderance of the evidence. That's 51% more likely than not. So they do have that advantage.
Isn't that gonna open the door for pretty much everybody now to like sue at some point or try to settle at some point? Because how can you prove? I mean, if something bad happened to you, obviously, it's probably a series of choices that you made. Obviously, social media have a bad effect. We cannot, not say that. But isn't that gonna open the door for everybody? So that's why, maybe Facebook wanted to go to trial.
Yes, I think that is. And I think they thought this was a winnable case. Facebook has said that they're going to really focus on causation. And I expect they're going to do that through the use of expert testimony. And I think it's going to be effective because unless they have a perfect plaintiff that can attribute all of her mental illness or adverse mental health consequences to social media, then I expect you're going to see experts that are going to say, no, 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 she had pre-existing conditions. She had problems before. They were environmental or they were genetic or I don't know, whatever all the infinite numbers of causes of mental health problems could be. Facebook or the defendants are going to try and demonstrate that. And I think it will be effective if they can show that. And that's kind of one of the challenges here in claiming adverse mental health consequences, which is that they're squishier than other more tangible health consequences. I know that's kind of frowned upon to say in today's age, because increasingly mental health issues, especially things like addiction, are seen as concrete a diagnosis as a fractured femur, but they're not. I mean, you can't say there's a much more direct line to showing that for years, inhaling smoke through a cigarette is carcinogenic, and those carcinogenics cause, guess what? Cancer. So I think that's an easier hill to climb. When it comes to mental health, I mean, even now in 2026, we have not yet mapped out the contours of the human brain. We don't fully understand what makes us tick there. So I think that's taking on a real challenge to say that something, just because it's a business founded on engagement and entertainment and people like it too much, I think that might be an extra step they can't make. And by the way, what you just mentioned, you couldn't be more correct. there are plaintiffs' attorneys all over the country watching this case very closely. And if it goes well, you are, I think, going to see the floodgates open up. I think this is only the beginning. I think this is going to be a big challenge for these companies.
I always remember the Better Call Saul. He's like, "Hey, anybody if emotionally affected by the plane?" Or yeah, did you ever see Breaking Bad and Better Call
Oh,
Saul?
yeah, of course. I
Yeah,
love Saul. Saul
and
was one of the
he
great TV characters of all time.
for sure. And he was like, "I'm not asking for a whole wing fall on you, just a little something, maybe a peanut or something." So they're gonna be that lawyer. Do you think what about the fact so it's of the responsibility of the family? Can the social media argue that? It's like, listen, it's there, we put it out there, we followed the regulation of the country and follow the regulation of the FDA and all that. It's up to to the parents and the adults in the house. Isn't that an
Right.
argument?
Generally, what the plaintiffs are arguing is that the danger, the product was harmful in a way that the parents couldn't really it was passed off in a way that it was safe to parents, but in fact it was harmful. But you're absolutely right. I mean, that's another thing they have to contend with, which is personal responsibility. Because it's a minor, that personal responsibility gets imputed to the parents. So I really think, the way for the defendants to handle this is to make this about bad parenting without explicitly pointing the finger and saying bad parent, bad parent. I think that's the way to frame this. I think you use experts to gently say, this is a child who may have suffered, but she was already suffering before she ever got involved in social media. But I think what you raise is a very valid point. And just taking people's temperature and talking about this case, I don't think you're alone in raising that question. I've heard that from a number of people. On the whole, I found mostly people that I've talked to, and that doesn't mean anything. This could go the other way. I think people have been a little skeptical of this case for the reasons that you just articulated. Look, I mean, where are the parents? That's a common refrain whenever you have a situation when minors are being harmed by some product. You can sue the product, but there's also, where are the parents in all this? And I think that the defense is going to do that, whether it's arguing causation, that she had pre-existing mental health problems, or simply generally putting it out there into the ether that parents have primary responsibility for what their kids watch. There's plenty of bad stuff on TV, but parents have to watch what channels their kids watch. So maybe it's the same with social media. But if the plaintiff's theory is, look, you marketed this to kids as safe and it was not safe, then that puts them in a different position.
I feel like also, the if you look at the big picture, I think we have failed. And that always comes to my mind when I talk about AI or do anything with AI, just like the amount of things that AI can do. I
Oh,
don't
yeah.
feel it's regulated yet. So do you think that we have failed to regulate social media and either like I know Australia did a great job but like okay, no, nobody under 16 have social media or can be in a social media, or stuff like that. Have we not, like, are we in a point where it's like it's too late, we should have done something right now, law wise, regulation wise, to because it's only gonna get worse, gonna be more people wanna sue, and that always takes away from the real danger, the real thing. Because people are
Yeah.
gonna think, oh, they money hungry now. But it's not about that. It's like about let's make it safe. Let's make it,
Right.
because it does have a lot of bad effects on people. It does have a lot of good stuff too, but also a lot of bad effects. So
So, is there enough regulation of technology? And I think the way I would always answer that is to say no, and there can never be, because of one immutable rule. This is always the case. Technology is always ahead of regulation. It has to be. Regulation always lags behind. You couldn't possibly legislate over technology before you know what the technology is. The way technology is, especially in the last 20 years, and by the way, it's only accelerating, and it's accelerating exponentially, not geometrically, exponentially. So it's the time, the lead time that technology is going to get on legislation is only going to increase and increase dramatically more every day, because it's always been the case that technology is way ahead of. We have to see what the technology is, and then we struggle to try and catch up and regulate it. Often with members of legislatures who are my age and older and grossly ill-equipped to understand technology. But yet, that is the system we have. So, is there enough regulation? I guess you could say there's never, not I wouldn't say enough, but never the proper regulation in the moment for what we're on the cutting edge of, on the edge of the wave, because whatever's happening right now, we couldn't have possibly anticipated. I don't think we could have anticipated AI. I mean, 6 months ago, about maybe a year, I started using AI, and my life changed overnight. And a day before that, I couldn't have imagined how different it would be a year from now. With
Yeah.
all my thought, if you and I had sat down and said, "What will it be like a year from now with this AI I've been hearing about?" And I wouldn't have imagined it. So the same thing with legislation that works even more slowly than our brains comprehending. It's impossible to legislate in real time over things like social media. And
Social
I
media
mean,
been around, yeah, been
yeah,
around
go
for a
ahead.
while, so why
Yeah,
wouldn't I'm not saying like regulate everything, but regulate an age, have like there's this example. I played this video game, not video game, like a game on my phone, and one of the things is like after a while, it just tell you you're out of life. You have to check back in 12 hours, so it's kind of like if it wasn't, maybe I would go more, but
right,
maybe something like that. I feel like they have to do it something like that to regulate. And the other part of it is like why we're not treating it. I know it's a little different, but then new medication comes in or new vaccine comes in or anything. You have a period of time until you know how safe it is, and then you start
right,
regulating little by little by little, because it kind
right,
of like that. It's affecting part of your body, which is the brain.
right. Well, I would say that we all have pretty short memories, me included. And I think we'd be surprised if we looked back on what our social media looked like even 5 years ago. I think the product is constantly evolving. If you go back to the early days of Facebook and even MySpace, I was on MySpace. I mean, you used it in a totally different way than we use social media now, and they're constantly tweaking it and adjusting the algorithms. And I don't know about you, but the algorithm really only started targeting everything I think about, that I look at, that I
Yeah.
mention out into the ether. All of a sudden, it shows up on my scroll. And for whatever they're doing, I admit I'm doom scrolling more than I ever did. And the funny thing is, Instagram used to be how I checked up on my friends. Maybe 1 in 20 posts on Instagram is my friend's post. Everything else is like dumb stuff that the algorithm has figured out that I'm dumb enough to want to look at, whether it be those shoot 'em up games or bizarro facts about ancient Egypt. I mean, none of Instagram is about me checking up on my friends anymore. So somehow they figured out everything Danny Savalas will doom scroll and look at forever, which is embarrassing because it's super nerdy stuff. But I mean, I don't. I think the product, although it's been around for 20 years, I think it's changing constantly, and it's only accelerating to get us more and more engaged. And you could call it engaged, others might call it addicted. I don't know that there's a clear line between those two things. That's really what this trial is about. I mean, how do these jurors define clinical addiction that's harmful, that you need to go to AA or you need to go to Gamblers Anonymous? You have to, you have a medical problem versus you're making some bad life choices. Like, I mean, is this, hey, you better not have that extra slice of pie? Or is this, I'm overeating and I'm 700 pounds and I can't stop? I don't know. And the answer is, I don't know. And that's what this trial in many ways is about.
It's very interesting that you chose two specific word, engaged or addicted, but
Yeah.
not entertained. Like, isn't that what's supposed to be the whole
Right.
idea? But now you're right, because all they want to do is to make sure that you are engaged.
That's it.
Yeah,
Yeah.
not even entertained, but just not, yeah, it's crazy. So to your point, having YouTube a part of Facebook and Instagram in the trial, is it separate? Like, because
No.
I feel like that's bad for them because they were like people can be like you and me. It's like, no, YouTube is not. So will Facebook get away because of things because YouTube is involved in the trial?
Well, if I'm YouTube, my approach is going to be we're not like that. But
Yeah.
here's the problem. They do use algorithms. I mean, I noticed that, on the and it's again embarrassing. I'm embarrassed by my own algorithm because when I look on YouTube, I look at some really nerdy stuff. And the algorithm, when I go on there, it's all suggestions for things that it knows that I'm interested in. And it's right a lot of the time.
What's
I
funny
mean,
to this point is like whenever I try to get somebody's new Instagram, it's like, hey, put your Instagram, and they're about to put it. They see everything that you like your algorithm. I was like, holy shit, no.
Ha-
I was like, just
Hatem,
give me a name.
I shouldn't do this on the show. but I will. This is the running joke among all my friends is my Instagram suggestion when you do the search. You know, like what you're talking about. People are they find to be the, and I'll tell you why this happened, and nobody believes me. I grew up in the 80s. So a couple times I start clicking on, I had an interest. I was super into when I was a kid into WWF, right? So I click on WWF. I think it's, I like to hear the old stories of Rowdy Roddy Piper and Randy Macho Man Savage. Well, the problem is the algorithm figured that that means I like bodybuilders who are all greased up. So, all oiled up bodybuilders. So when I do the search, it is head to toe muscle bound guys flexing and oiled up and like, I mean, candidly, when my friends, they have stuff that is more mundane, like hats or dinner or a glass of wine, but I have Randy Macho Man Savage all oiled up, and I understand why it's doing that, but my friends relentlessly tease me about it.
That's so
And then,
funny.
by the way, when I explain, no, it's because I looked at WWF. That's not much better. Like
Yeah.
the truth is not much better. I'm in just as much trouble.
It's so crazy. In this show, Noam and I went, especially during the Israel-Palestine, Gaza thing, war. We obviously both very passionate about it, and he's taking one side, I'm taking the other. So I think the algorithm, if they're watching Noam, they give me stuff pro-Israel, and then start watching me, and then give me stuff pro-Palestine. And I think they
Yeah,
just gave up. There's like, you know what? We
right,
don't know what this guy wants with
right,
which one. It's like, no, it's two different people,
right.
but it's crazy. But what about the regulation of age? If we go back, so we have an age for to join the military, which is, in my opinion, way too young. You know,
You think
uh,
it's too young?
I think it's too young.
Even though in the world wars, you have all these stories of 14-year-olds and 15-year-olds who lied and were able to get into it's crazy. It's been a lot younger than that in American history for sure.
Yeah, and I don't think it's right because
Yeah,
it's again the way they sell it to you is exactly like social media, and I think Bill Burr have this joke about like it should be like old men because we're so fucking angry and just and have
yes,
nothing to lose,
yes,
but
embittered.
I feel kids have, it's good to be part of a military, but not in combat, in my opinion. I
Yeah.
think it's too young. But if we go to ages, like who decide the age of voting? They decide the age of consent, the age of the military, all this. But yet, when there's a lot of money behind it, like social media, nobody's deciding shit.
Yeah. Well, I think it's always fascinating that we have nationalized some ages and we have localized other ages, like the age of consent is a classic example. And by the way, the age of sexual consent is not only a different number from state to state, but I don't know if you've heard of what are called Romeo and Juliet laws, right? So we have an interesting set of laws, and I don't know how we would do it differently, but we have an interesting set of laws where, if a 15-year-old has sex, the person who had sex with him, it's a crime. But under what are called Romeo and Juliet laws, if the other person is close in age to them, isn't that interesting? Because the experience of the victim is still the same in either case, right? I mean, it's kind of a legal fiction that we say, because if we truly say that a 15-year-old cannot consent, it should be automatic. Whoever has sex with a 15-year-old has committed a crime. But we make an exception if they're within, I don't know, I remember it being 3 or 4 years, depending on state to state. And they call it Romeo and Juliet because we don't want to criminalize high schoolers who are romantically involved. And yet, it still is functionally an underage person having sex, but we've sort of created this legal fiction where we say, okay, that's sexual assault, but not if the person's close to their age. It's an interesting thing. It's one of
Hmm.
those legal definitions that I guess it makes sense, but logically it's interesting. I mean, I think people might have differing opinions on that. So the point is that we not only have a sliding scale of what we think the proper age of consent is, we have a sliding scale on who that person can consent with, which is fascinating. I mean, it's just
Yeah.
a fascinating, but again, I think you would, if you explain that to a number of people, they'd say, oh yeah, that's kind of the way it's always been. We make a huge distinction between a romantic couple in high school and a student in high school and his teacher, right? I mean, that's a crime, and
And I think also
rightfully
if they
so.
married, if you marry someone, can you marry someone?
No, no, it's no, not in any state that I'm aware of. I mean, it's unlawful anywhere.
No, I'm
I
saying the
mean,
age of marriage. Is there a set
oh,
also age of
yes,
marriage? Yeah.
yes, yeah, it's the same as consent because
Oh,
arguably because part of marriage is consummation.
yeah.
So that would make sense.
So we have the voting age, which is, people keep saying, hey, it should be younger, should be older, should this, and we have the military age, we have the age of consent, but we don't have age for something that like social media.
No,
Do you think you should have it?
I think it's possible you could see Congress at some point create minimum ages for social media. But the reason I think that may not be successful is this is what is happening exponentially. What technology is doing is giving us access. And that's what social media is. It's access with the outside world. It's access to information. And if you look through history, anytime that governments try to restrict access purely to information or communication or contact with others. Now, even if that contact is a silly game or, I mean, it's hard, it hardly seems as noble as the kind of contact someone in North Korea wants with the outside world. It seems weird to compare that to the importance of I have to play my addictive online game or I have to, create an Instagram filter of me with a funny face. But look, contact is contact, and that's valuable to people. So I think Congress is very reluctant. Any Congress would be very reluctant to suppress people's access to information because don't forget, access to information. I say don't forget. I mean, your business is essentially in the world of free speech, but access to information is one of the bundle of rights that makes up free speech. It's not just the right to speak; it's the right to have access to information, to have access to speech. So I think it would be very difficult. I mean, yes, you probably could create a minimum age for accessing social media, but I think what would happen is young people will do what young people have done since for millennia, which is access the forbidden thing, the thing they're not allowed to access. Whether that was 30 years ago, kids hiding a Playboy magazine in the woods and going to look at it, it would be the same thing now. You can make rules about kids sneaking out and meeting members of the opposite sex, they'll break them. You can make rules about kids not having access to drugs or alcohol. Some of them are going to find a way to try it. And you can do the same thing about restricting communication, access to information, social media. You can try, but kids are going to find a way around it because that's what
Yeah.
kids do. Kids have
Yeah.
done it for millennia. I mean, even if it means they tried cigarettes once when they were 15 and never did it again, that's what kids do.
And I think it's not only kids. I think even with the older generation, it used to be just access information, but now it's access the information that you want. Like if you have an opinion, like if we argue about anything at all, let's say vaccine, and my opinion is vaccine is good, and your opinion is vaccine is bad. You can research and you can find expert that agrees
Both
with you.
sides.
Both of
Both
us.
sides. Yep.
Yeah. So, and that's it's not access information anymore. It's access support of your point of view, which is a major problem, because it used to be like, and that's why again back to YouTube. I think YouTube is a great source of a lot of things. Whenever I
Oh my
want to,
gosh.
interview somebody, whenever I know anything, whenever I go to YouTube and you can tell right away if they're full of shit or not, so you can skip. But now, it's not only access information, it's too much information. And with AI, you're gonna see crimes, you're gonna see shit, you're gonna see interview with the people, things that they didn't say. But obviously we don't want to restrain either. We don't want to be North Korea. And speaking of North Korea, there's a very funny story because the World Cup is coming up. They don't have no access to information, no access to
Oh
the
yeah.
whole world. Do you know that North Koreans think that they won the World Cup 3 times?
Amazing.
They had
I
no
believe
idea.
it.
So
I
the
believe
the
it.
the president of North Korea a couple of times will send the team and then they come back with a trophy and say that they won the World Cup. And the people like think that they're the world champions. They had no idea,
Brilliant.
you know. Uh, but obviously, it's also, I think that social media was huge, like in the Gaza war. Like we would not have seen all the shit, the bad thing that happens
Exactly.
if you have not seen the videos with your eyes and be like, oh shit, this has actually happened, And this is why, a lot of like, imagine if we have, social media back at the Holocaust. First of all, you would have saved a lot of people.
Yeah.
And
Yeah.
second of all, you would have like documented, even though it's the most documented thing. I mean, I think Gaza now is the most documented, but it shows you things, and I think people can get away with shit, especially in the rest of the world, in the Arab Spring, the social media. And this is another thing, is like when in Egypt specifically, which is millions of people, when the revolution happened, the dumbest thing the government made, which was, the kids were communicating through social media. He's like, let's go and protest. So they went down and they organizing, and they had like a couple of million people. So the government decided to shut social media so they don't communicate. So when they didn't communicate, they're like, I don't know what's going on. Let's just go on the street. Now it become 100,000, 100 million people, So you could have just made it in a way. So of course, social media have a lot of great things. And I like specifically say about, the Gaza war, because I think you would never have seen what you've seen if it wasn't for them. Also, a lot of people, that get kidnapped or stuff, and they chose they you can get located by social media. A lot of people were
Yeah.
trapped, and so there's a lot of things. But also, I think back to the point of accessing information, it's too much, not information, too much opinion out there. So it needs some kind of regulation. I don't know how they do it, but they got to do something about it. I don't know.
Yeah, I mean, yeah, I mean, we have long said that look, children are different. You can regulate what they have access to. That's acceptable. But I always go back to, you can regulate it, but you might actually have a rebound effect where you make it more interesting to kids by making it forbidden. And especially in matters of speech, you can regulate kids' speech. I mean, kids don't have the same free speech rights that adults do. They never have. But again, it is regulation of speech, and it's both legislatively difficult and historically difficult because kids just want
Yeah.
what is forbidden to them, and I think they'll find a way to get it.
And what's funny is like people now check like if you like meet a girl, meet a boy or whatever, and or have a job in it, whatever, and you check your phone, your messages, your Instagram, and he's like, okay, nobody called me in all of them. Damn it. Remember when we were kids, if you left your house and you have the phone in the house, that's it. The plan is done.
That's it. And you know what's amazing? I think that has contributed to being able to back out of things. I'm getting old, so like I get that on Friday night. I'm like, oh boy, I'm tired. Unless I'm going to Hot Tem's fantastic comedy night, which is
Right.
really one of my favorite things to do in the city. But I every Friday, folks, New York City, somewhere. Wait, somewhere, no, somewhere, nowhere. Right? That's
Yep.
the hotel, right? Yeah,
Yep.
because the name of the event is similar. I sometimes get confused, but it is one of my favorite things to do in the city. But even that being my favorite thing to do in the city, being an old person, it gets to be 6 o'clock. You're like, oh boy, I got to go out. I got to get dressed. And no matter what, even for my favorite things. And I think you're right. When we were younger in a pre-cell phone era, when we used to go out, you had to commit because once you were out, no one could find you. If you forgot your
Yeah.
wallet, if like you changed the plans, there was no changing the plans. You're going to Susie's party and then you can figure it out from there. But everybody's going to the same place.
Exactly. And you can't be like late. You can't be, it's like, okay, 6 o'clock, we're meeting here. That's it. If it's 6:30, there's no, so sometimes not being found is a great thing. So la last question about this part, and I want to move on to something else. As a parent, what do you think?
As a parent, I tell myself I'm going to be a tyrant and not allow them to do anything. Everyone tells me I'm nuts. I'm already something of a pushover, but I think I will be militant about social media, and I already can sense they're going to, whatever I forbid, they're going to sneak around and do it. I I think my approach is going to be nosy, unapologetically nosy, and strict, and understanding they may, go out and do things on their own. I mean, my wife is she would describe herself as a huge homebody. She's not a wild child at all, and even she. When she was at Catholic school, she'd leave in her uniform and they'd like tape up their skirts an extra inch. You know what I mean? Like to be racy. I don't know what, but all kids are defiant. So I know that either way, I'm not going to have that much effect. It's going to be their peers, but I am going to be at least try to be militant. I just don't see. I already have an issue with them, watching YouTube, and I say that because I'm guilty. I grew up in a household where we were just sort of left to watch TV. And man, did I love TV. I watched some gosh darn TV. I used to watch TV from the second I got home from school until I went to bed. And I kid you not, I knew the whole lineup on TV from afternoon to bedtime, Transformers to MASH. And I know those words mean nothing to most of the people, young kids out there. I knew everything. G.I. Joe, Laverne and Shirley, I watched everything. And so I already see them spending a little more time than I'd like on YouTube, and they're already wanting it and kind of complaining if they don't get it. So, as much as I had these plans of this purist lifestyle, I was kidding myself, I think.
Yeah, it's great. Again, it's sometimes like say in sports or stuff like when we grow up, if you want to learn a move or shooting or in any sport, you only have your coach or yourself,
Yeah.
but now you can go to
Oh,
YouTube
yes.
and watch
Oh,
tutorials and be like, oh shit, okay, I can do this, and you can practice. So, it's very confusing. It just need to be regulated somehow, internally or by the government. I don't know. Not in like,
absolutely.
hey, you cannot do that, but I don't know. They gotta like because this is the idea with technology. They're gonna be a technology to regulate the technology. When the internet came, there is an antivirus, so it
Yep.
must be something.
Oh, yeah.
All right, let's move quickly to the couple of other things before you go. Don Lemon, what's your thoughts on this whole thing?
So I love Don Lemon as a person. Don Lemon, I have a funny story. Don Lemon outed me and my wife as dating when we were secret dating at CNN. And to his credit, I mean, this must be the journalist in him. It's an amazing story. There were probably 20 of us CNNers on site. We were covering the protests of the death of Freddie Gray, who had died in police custody. This is going back over 10 years ago. And we were all in Baltimore at a hotel, just having a nice drink after a long day working. Everyone's having a beer. Don, sitting at the bar 10 feet away, shouts across the bar just from seeing the body language of me standing next to my then girlfriend, now my wife, who you know. He shouts, "Hey, are you two dating?" He figured it out from us standing next to each other. And we of course denied it, but then the rumors started flying, and it wasn't long before we were outed. And it didn't matter, I guess, because we got married. But yeah, I mean, so that being said, um, here's the thing. The statute under which he is charged. There are things that people are talking about, and things that I think matter, and things that I think don't matter. One of the things people are complaining about this prosecution is that they're using a rarely used section of a federal criminal statute that is ordinarily used to keep people from interfering with abortion clinics. Now, when Congress passed this law, what they did as kind of a concession, so this could be a bipartisan law, and it was passed with bipartisan support. But the way that sausage gets made is that in Congress, what happens is you have a law that says, thou shalt not interfere with abortion clinics. Well, people on the right are going to say, well, we want something for us. If we're going to approve this, then you also have to have something in there about interfering with places of religious worship. So that's how we get this law. Practically speaking, it's been used almost every time to prosecute people who interfere at abortion clinics. It's virtually never, or maybe never, been used to prosecute anyone who interferes with a religious ceremony. But here's the thing. I don't think that matters. The rareness of the use of a statute does not matter because Congress passed it, they enacted it, it exists. The mere fact that it's rarely used, that might go to a moral argument that it's selective prosecution. It might even go to a legal argument that it's selective prosecution. But the problem with selective prosecution is that it's almost never successful because all prosecution is selective, particularly all federal prosecution is selective because the federal government can't prosecute everyone. They have to pick and choose. So every federal prosecution is, by definition, in my view, selective. So that is not a compelling argument. The fact that this is a rarely used criminal statute, that doesn't mean much to me because if it exists, it can be used. However, I do think that Don Lemon has a number of defenses. And I think this case is a good chance it'll never get to trial. And if it does, I think there's a very good chance Don Lemon gets acquitted. That's saying a lot because federal criminal cases have a 90+% conviction rate. And I think Don Lemon has a good chance at an acquittal. First, he has First Amendment defenses. But second, the statute of him itself, I don't know that they have enough. And here's why. It's not enough under the statute to interfere with with a religious ceremony or religious event. You have to also intimidate. Now, the theory of liability is that he engaged in a conspiracy, and that conspiracy, the plan was to intimidate and interfere with the religious event. So, uh, so they, so the argument then becomes that they have to show that he actually intimidated the people there or conspired to do so. I don't think they can do that. I don't think they can do that.
Is he when you're independent, like you don't work for a network, are you still considered a journalist? Are you
I'm not like a
protected? Are you
legal.
kept? Because he keeps saying I'm a journalist. But I
I'm
wonder.
not. Actually, I don't think of myself as a journalist. I think I'm kind of journalism adjacent. I'm a legal analyst, so I come on as a guest and talk about things. But I mean, I don't know that I would. I don't think I would consider myself a journalist. I'm not a reporter in the traditional sense, although
But he
sometimes I.
keeps saying as a defense, like I'm a journalist. I'm
Oh,
supposed.
his defense, yes, he. Yeah, but I think he look. Journalism, the definition has expanded dramatically, but journalism is an expanding definition. And I think from a legal standpoint, it doesn't make all that much of a difference from a First Amendment perspective. But I mean, because people have a First Amendment privilege, protection, a freedom of expression that allows them to do a number of different things. It doesn't allow you to trespass. And maybe was he trespassing? Maybe. But trespassing is a state offense, and he wasn't charged with the state offense of trespassing. Maybe you have that there. But this federal crime, yes. And do I think he's a journalist? Yes. I mean, I don't think you need to be a.
I'm talking
I
about
don't think.
legally. Is
Yeah.
that term legally if you are independent? Because we see a lot of, you know, former news
Right.
people, they start their own thing and say, but he was saying, and I'm a journalist, I'm allowed to be here. So I was wondering if the law itself sees,
Well, he's not allowed to be there. I mean, that's
yeah,
that's a bit of a misstatement
yeah,
because he's not allowed to be there. If they tell him to leave, it doesn't matter if you're a journalist or what you are. You got to
yeah,
leave. It's
yeah.
time to go. So, but again, that's a state crime of trespassing. At best, it's a misdemeanor. But is this the federal crime of interfering? Well, yeah, I think he has a major First Amendment defense because he wasn't conspiring, merely talking to the people. I mean, that's what journalists do. They go out and talk to people. So if you're going out and talking to people, yes, did he go there beforehand? Yes, was he friendly to them? Yeah, but I mean, that's what reporters do. They befriend people to get the story from them. So I don't think that's enough either. I just think this is a case that I think it's going to be a real uphill battle for the prosecution.
All right, last one. Your final thoughts on Maxwell do it taking the fifth, Bon Bondi's crazy testimony, and the Epstein
Oh yeah,
updates in general.
yeah. So a couple of these. I mean, the Epstein document. It's been a fire hose of information, and some of it is compelling, some of it's not. My takeaway, and it's just so strange for me to feel this way, but I now feel like we've proven why, as a general rule, we have grand jury secrecy, and the federal government does not release investigative materials unless and until they're used at trial or there's a good reason to, because I think a lot of this stuff has created more confusion than anything. I mean, there have been names of a lot of people released who, maybe they didn't do anything. We don't know what they did. Some people certainly look more culpable than others, but there's some people whose names are just in the files. I think it's been chaos. I think this is, as much as I know it's important to shine a light on things, I don't know in 10 years if we look back on the Epstein files release and we say, did the good outweigh the bad? I don't know. I don't know. I mean, I guess transparency it's not an absolute good. I think transparency is a good that approaches absolute. I think it's almost always good to be transparent. 100% transparency is not good, right? I mean, to use a silly example, transparency of our clothing would not be a good thing. Like, we don't need to see and know everything. Um, but I don't know, that I don't know what we've learned. I don't know that any prosecutions will come from this. I don't know. I don't know I don't know what the net benefit has been. It's been pretty gruesome. Some of the stuff has looked pretty terrible, but I don't know. As for the Pam Bondi hearings, bananas. I am fascinated with them because I think they are kind of a watermark for us of where, in the old days, a zing was Ronald Reagan saying that his opponent is he wouldn't hold his opponent's youth and inexperience against him, or Lloyd Benson in a debate saying Dan Quayle, I knew John Kennedy, you're no John Kennedy. Those were dunks, those were zings. Now it's just Pam Bondi calling Jamie Raskin a loser lawyer. I mean, it's funny. I've heard Joe Rogan. I first heard Joe Rogan say it, that Trump is a comedian, and he's sort of created this atmosphere of just come up with the clunkiest insult and it's a zing. Maybe that's where we're going. I mean, she basically was in front of Congress saying, "You're dumb. You're a loser." It's crazy, but I mean, that's the new normal, or maybe it's the normal at least until the Trump
Can you imagine
administration is
that's
gone.
yeah? Can you imagine that Robert F. Kennedy being in that seat doing that? It's
Can you
insane.
imagine?
Yeah,
It's bananas.
yeah,
I mean, it's absolutely bananas. I don't know what to make of it. But I was fascinated by it. And as it is with most congressional hearings, as crazy as it is, I feel like not a lot of people noticed it.
yeah. What's interesting about the Trump era in general, like, and you have to give him credit for that. Either like people will not watch these boring things. I think more people watch this. The trial and the testimony and stuff. Like regular
Oh
people
yeah.
don't even watch. It's everything with him is so entertaining, so wrong but so entertaining.
Oh yeah.
Maxwell taking the fifth.
Maxwell taking the fifth. So I mean, I'm not surprised. Here's what Maxwell's doing, and I can't blame her. She and her legal team are doing everything they can to try and get clemency, either a commutation of her sentence or a pardon. I don't blame them. I mean, short of lying, I don't encourage lying or perjury or anything. But everything they're doing is positioning themselves to curry favor with Trump because they've got, I think, a more than even chance of getting a pardon from Trump. And the reason I say that is all of her other options are hopeless. She's down to filing pro se habeas petitions. She's got no chance other than Trump of getting out of prison. So, what would any of us do to get out of federal prison? I mean, obviously shouldn't lie, but that's part of the strategy. And the reason she's taking the fifth, I believe, is that isn't so much that she's worried about self incrimination. She is. I mean, she should be. Just because she's convicted for one crime doesn't mean she doesn't have information that could incriminate her otherwise. But more than that, her information has value and it's a bartering chip. No matter what it is, if it's good for Trump, it could help her. If it's bad for Trump, it could help her. So, and to a large degree, we learned a lot from her interview notes. We've learned a lot. We know a lot of what was going on with her. But I think strategically, the reason she took the fifth was to control the environment and to curry favor with Trump. I don't think it really had to do as much with self-incrimination. I think it had because she sat down with Todd Blanche in DOJ and told him whatever he wanted to hear. And then she takes the fifth. So that signals to me that she knows where her bread is buttered. Congress can't pardon her. The judiciary can't pardon her, but Trump can. And
Yeah,
Trump's the only person on earth, the only president who will do it. I mean, maybe JD Vance, but I doubt it. I
yeah,
think if JD Vance gets in as president, I think he'll be quite a bit different than Trump.
yeah. Well, we'll see. Let's hope he's not. But I don't know. Danny, always great to have you, man. Make
Uh,
sure to watch the Danny Savalas show. It's always full of information. He's the best to break down everything. Great to have you, man. Always.
Thank you, my friend. Such a delight. Love seeing you, pal.
Thank you very much. Live from America.